Next up, we go to a very interesting yet disturbing matter from KZN on the issue of privacy, that is CEA versus MB under the pen of Mossop J, which was interdictory relief sought by the applicant against the respondent who accessed and recorded private footage of the applicant having a sexual encounter without her consent. The footage was later shown to third parties, severely compromising the applicant's right to privacy. The court had to determine the appropriate remedies and sanctions. Court took a very heavy-handed approach against the respondent, quite rightly so. It looked at the constitutional right to privacy, Section 14 of the Constitution, protection against unlawful intrusion and dissemination of private information, and it also looked at the unacceptable nature of the respondent's conduct and the necessity of punitive measures in terms of a costs order on attorney-client scale. The respondent was interdicted from publishing, disseminating, or disclosing the video showing the sexual encounter. He was also ordered to pay the costs of the applicant on an attorney-client scale. Very important judgment in terms of the right to privacy in the more acrimonious matters where we know sometimes clients take action which is very unsound, and this is definitely a cautionary tale to litigants. Court saying at paragraph 38, the respondent's logic is unsound. He previously acknowledged that the house at which the applicant resided had previously been the matrimonial home. It was no longer. It was no longer his home, and he had no rights to it. He had no right whatsoever to inspect the contents of the hard drive. The fact that his clothes were in that house, as he alleges, and that his son lived there, endowed him with no right to do any of the things he did. This one I put in obviously because we know that very often when one spouse unthinkingly vacates the matrimonial home, they get a little bit of a bee in their bonnet of wanting to go back into the house. And this is obviously a nice reality checking situation.